tonight, right now, the Supreme Court fight is in its most pivotal phase. Democrats pressing Trump nominee Brett Kavanaugh in a session that's expected to run well into the night. Now, Democrats have largely shifted from yesterday's demands for documents to regular order today. But many protesters not making that pivot, continuing direct action protests to argue this whole hearing is illegitimate. They point to Republican hypocrisy in blocking Obama's nominee and to the concern that a president under investigation shouldn't get to ram through a judge who could rule on that very case or rule on Trump's reported efforts to end the investigation, which would include the attempted firing of special counsel Bob Mueller, which Democrats pressed today.
And is that special counsel fireable at will or only for cause, in your conception of what's the most appropriate structure?
So that's the hypothetical that you're asking me.
Hypotheticals are word nominees use to duck answers. Kavanaugh also did that on the pretty straightforward question of whether the Constitution allows a president to pardon himself. That's something even Richard Nixon didn't do.
President Trump claims he has an absolute right to pardon himself, does he?
The question of self-pardons is something I've never analyzed. It's a question that I've not written about. It's a question, therefore, that's a hypothetical question.
Does the president have the ability to pardon somebody in exchange for a promise from that person they wouldn't testify against him?
Sarah, I'm not going to answer hypothetical questions of that sort.
You can see there why the hearings are so exciting. Now, Kavanaugh did try to show where he stood on the hypothetical of overturning Roe versus Wade. He said it's not only important, but sort of a super precedent because it's been reaffirmed so much.
What would you say your position today is on a woman's right to choose?
Well, as a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent.
Precedent on precedent. I am joined by people who know their way around precedents. Sherrilyn Ifill is the president of the NAACP Legal Defense Fund. Elise Hogue, president of NARAL Pro-Choice America. And my favorite legal eagle, NPR's Nina Totenberg, who is furiously still covering the hearing there at Ground Zero. My thanks to all of you. This is big. Sherrilyn, off the top, did Judge Kavanaugh help or hurt himself today?
So I think he hurt himself today, and I want to disagree with you. This was very exciting.
It was exciting.
It really was.
I didn't realize. Now I know it was. I was there all day today and yesterday.
You missed it. There were very important moments, and we learned a lot about Judge Kavanaugh. And there was a mix of substance and process that was really important. You know the whole issue about the documents we don't have from Kavanaugh's time when he worked for President Bush. That was interwoven with some of the colloquy that you showed at the top of the hour. Senator Leahy, for example, brought a line of questioning about whether or not Kavanaugh had received confidential documents that had been stolen from Senator Leahy in 2002 at the time that Kavanaugh worked on judicial nominees. And what Leahy did was he questioned the nominee up to the point that he couldn't use documents that the chair of the committee has deemed committee confidential. And Leahy said something pretty extraordinary. He said that he had documents that would contradict the testimony that Judge Kavanaugh was making right in the chambers. Later, it happened again with Chris Coons from Delaware. He was engaged in a really important colloquy with the nominee about executive power, executive privilege, about the Morrison case, and about the independent counsel and the special counsel, and whether the president has the power to be free from investigation while in office, which is the key issue with Trump. And Coons said that there are 4 documents that he thinks are critical from Kavanaugh's past to be able to flush out the answers.
Which goes to the secrecy that Democrats have been hammering.
That's right.
Turning to you, Elise, one thing I've learned legally is that generally if I have a legal concept and Sherrilyn Ifill has to correct me, she probably has it right. So they were exciting hearings, and I want to correct that for the record. My question to you is, what does it tell you that more than any other issue or, quote, hypothetical, Roe and choice was the place where Judge Kavanaugh claimed and suggested and intimated that he will not overturn Roe?
I did not hear him say that one bit. Super precedent is not a thing. And what we did hear, and what we've heard all through his meetings, is he believes in Roberts' interpretation of settled law, right? Roberts has been a reliable anti-abortion vote every step of the way. He did say, you know, he used a lot of code language, and in fact, Senator Blumenthal called him on it afterwards. He used a lot of abortion on demand language, which is code to the anti-choice movement. In fact, after your super precedent comment, Life News sent out a missive to their members being like, pay no attention.
It's all good. Well, let me bring, again, for viewers who aren't watching the entire exciting hearing, let me play a little bit more of the so-called super precedent from Kavanaugh today.
Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. Roe v. Wade's an important precedent of the Supreme Court.
This is something central to a woman's life. When government controls that decision for her, she's being treated as less than a fully adult human responsible for her own choices.
I think you see the contrast right there, Ari, and I think that that's what 60% of Americans in an ABC poll said that they wanted to hear Tuesday morning. They want to hear straight answers on whether or not he is actually going to embrace the idea of the fundamental freedom of access to abortion. What you did not hear him say, which was very, very disturbing, was when Senator Feinstein reminded him that women died before Roe, what he said is, I understand you believe that. I understand you feel passionately about that.
You thought that was a tell.
He did not say it's factual that women died. I have concerns that women might die again. And so what we heard was code words that gave no one any sense of comfort who sits where I sit, that he will do anything other than end Roe and criminalize abortion, and a lack of empathy for the consequence for millions of American women.
Let me go to Nina Totenberg, who, as I mentioned, is covering the hearings live. We just talked about the secrecy issues as well as the choice issues. What else do you think came through in this hearing today?
Well, I thought actually the exchange with Dianne Feinstein about guns was pretty illuminating. Judge Kavanaugh, as a judge, wrote a dissenting opinion, dissenting in a panel where the other conservative members of the panel upheld the D.C. ban on semi-automatic assault rifles and magazines of more than 10 rounds. And in that dissent, he basically said that in the view of the Supreme Court, this is the way he interpreted a decision, and his view, that the right to bear arms is analogous to the right of free speech, and that we would no more ban a category of arms than we would a category of speech. That was his dissenting opinion, and he didn't walk back from that at all today.
Right, which is crazy has been the word of the day here, colloquially in earlier blocks about this op-ed. That's, many people would say, legally crazy pants. I mean, it's well known
I wouldn't
that
say that. I would not say that. There are people
I'm not
who
saying you
believe
said that.
strongly
I'm saying,
as a legal view, but
I'm saying it's crazy pants, just so that everyone understands. But because obviously you can regulate grenades and nuclear weapons differently than smaller weapons. The notion, I think, that the Constitution forbids that is a stretch. I want to also play for you, Nina, some sound of hand raising, really, that shows that Kavanaugh had at least publicly presented the idea that you can't indict a sitting president. Previous to today, take a look.
How many of you believe, as a matter of law, that a sitting president cannot be indicted during the term of office? Just raise it up. 1, 2, 3, 4, 5, 6, 7, 8, 9. More than half the panel believes.
That was a public answer. Then how did that compare to his answer today in your view of the way the Mueller and criminal probe questions came up?
Well, as he pointed out, the position of the Department of Justice has for 45 years been that you cannot indict a sitting president. That's why the Watergate special prosecutor made Richard Nixon an unindicted co-conspirator. Now, that doesn't say you can't present information to Congress of criminal activity that would lead to an impeachment, but the position of the Department of Justice in Democratic and Republican administrations has been that you can't indict a sitting president. And so in that sense, it's not extraordinary, but it does feed into his other views, often expressed, that investigations of the president are harmful. He has proposed in a law review piece legislation to make criminal investigation of a president something that can't be done during the president's term of office, or even civil suits. And it's clearly his experience also, as he made very clear today, after 9/11, he said for George Bush for the next year, every day was September 12th, and that anything that diverted him from that was harming the country. And that is, I think he's made pretty clear that he has grave doubts about how far you can go investigating a president. And he very carefully did not answer or suggest any answers or suggest that he did not even fully embrace today the Nixon tapes case. He said that he thought it was one of the great decisions of the court because the court stood up, was independent, and stood up in a time of national crisis. But when Senator Feinstein pressed him on whether he thought it was correctly decided, he hemmed and hawed.
Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.